here in the case of Barron versus White. Are the plaintiffs ready to proceed?
Yes, Your Honor.
All right, defense ready to proceed?
Yes, we are, Your Honor.
All right. Plaintiff wish to open to the jury?
Good afternoon, Your Honor, members of the jury. My name is Rebecca Braulio, and with me today are Joe Savage and Michelle Worth. Together, we represent the plaintiff, Pat Barron. Pat Barron is your average 17-year-old high school student. Many children her age, she is involved in extracurricular activities. Pat, however, is especially devoted to writing for the school newspaper and playing basketball. Ironically, it's because of these two interests that we are here today. You see, there is something that makes Pat different from other teenagers. When she was 13 years old, she was accidentally hit by a ball, and as a result of this accident, she lost the sight in her left eye. But this did not dampen her spirits for long. Pat resolved to continue to pursue her activities, not only in school, but in all of life. And she refuses to allow her blindness become a handicap to her. Even today, Pat is still involved in her activities, including playing basketball. For example, in middle school, she tried out for the team. Not only was she the team captain, but she was also second leading scorer. In addition to this, she also played on the summer league team. However, when Pat tried out for the Averill High basketball team, she encountered some problems. She first tried out her sophomore year, and at these tryouts, she wore protective safety goggles because they made her feel more secure on the court. You will hear Pat testify today how she quickly learned that these goggles seriously affected her vision as well as her ability to play well. Pat did not make the team that year. This year, things turned out a little differently. During the week of October 22nd through the 29th, Pat tried out for the Averill High team a second time. This time she made the team without wearing any safety goggles. This is where the defendant, Bobby White, comes into the picture. Bobby White is a world cultures teacher at Averill High School and is head coach of their team. He is an Armed Forces veteran, and while he was in college, he received an ROTC scholarship. Coach White dropped Pat Barron off of his team 5 days after he learned about her blindness. Now, he claims that this decision was based on the fact that Pat's blindness in her left eye made her a threat to her own safety as well as that of her other teammates. He gave her an option, one he knew she couldn't take. To continue to play on his team, Pat would have to wear the goggles. This was unacceptable to Pat, and she gave him her own compromise. She and her parents offered to sign a release form that would release Coach White and the school board from any liability should an eye injury occur on the court. Coach White still refused. Pat Barron and Adrian Dove, who is a colleague of Coach White's, will show you today that Coach White's reasons are not valid at all. In fact, Coach White does have ulterior motives in dropping Pat off of his team. You see, Pat is a contributing editor to the Averill High newspaper, and she happened to write an editorial that strongly criticized President Bush's Persian Gulf policy. Despite what the defendant says, he was offended by this article. Because of an article that she wrote, Coach White dropped Pat Barron off of his team. The plaintiff will prove to you today that Pat Barron was unjustly removed from that team. You will also learn that by wearing safety goggles will only impair Pat's game and will in no way lessen the supposed risk to herself as well as her other team members. We will also show you that Coach White has violated Pat's right to freedom of speech and the right to control over her own body. There are two sides to the story today, members. One has a solid foundation and is written on logical facts. This is made by the plaintiff. The other is only a tall tale based on opinions and excuses. This will be told to you by the defense. The plaintiff asks that you listen carefully and attentively to each fact presented today and find in favor of the plaintiff.
wish to open now or reserve the opening until the beginning of the defense?
The defense wishes to open now, Your Honor.
All right, you certainly may.
Your Honor, members of the jury, counsel, may it please the court, I'd like to begin by introducing myself. My name is Jason Dean. I'm an attorney for the defendant. My co-counsels are Larry Mathers and Jonathan Schmidt. It is very dangerous to throw around accusations of civil rights violations. Immediately, the worst fears of American people are aroused. If you are going to make such accusations, you better have proof. But today, in this case, the plaintiff has no proof. They make very serious accusations of First and 14th Amendment rights violations. But for evidence, they offer only the assumptions of an embittered art teacher and a disappointed young high school student. We, the defense, ladies and gentlemen, offer facts. The first fact is that on November 1st, 1990, the plaintiff was provisionally, not officially, but provisionally accepted to the Alville High School basketball team, pending the results of a physical examination. The whole point to this physical examination was to determine if athletes had any hidden impairments which would prohibit them from playing basketball. Well, on November 2nd, the examinations were held, and it was determined that Pat Barron was blind in her left eye. On November 3rd, the defendant, Coach Bobby White, was informed of this impairment. He was faced with a dilemma. He wanted to keep Pat Barron on the team, if at all possible. He liked her. But because of his long experience with basketball, Coach White knew that the risk Pat Barron's impairment posed to herself and other players on the team. Well, Coach White knew that these risks were simply too great. And after consulting the school principal, the school doctor, and a sports medicine doctor, he came to a decision. However, being a cautious man, he took 2 days, November 6th and 7th, to observe Pat Barron in the context of carefully controlled practice sessions. This observation served only to reassure him. On November 8th, he informed the plaintiff of his decision. He told her that she would have to wear protective goggles to continue playing basketball. Pat Barron decided that this was unacceptable. Pat Barron then exercised the very 14th Amendment rights that she claims have been violated. Pat Barron chose to leave the team. It was only later that the plaintiff, disappointed with her decision, finally facing the reality of her impairment, invented charges of civil rights violations. She accused Coach White of dismissing her from the team because of an article she'd written in the school newspaper concerning troop deployments in the Gulf. Members of the jury, Coach White served in the United States military for 20 years as an officer under the oath that he would uphold the Constitution. He put his life on the line numerous times, not to preserve the flag and its wavers, not to preserve a false sense of patriotism, but to preserve the ideals in the Constitution and the Bill of Rights, the very ideals that allow Miss Barron to voice her displeasure with President Bush's actions. It is preposterous to suggest that Coach White would put aside everything he stands for and dismiss a player because of her political ideology. No, ladies and gentlemen of the jury, there were no civil rights violations. Coach White did not dismiss Pat Barron from the team because of an article she'd written in the paper. Coach White never even read that article. In fact, Coach White did not dismiss Pat Barron from the team. Pat Barron chose to leave. All Coach White did was inform the plaintiff that she would have to wear goggles to continue playing. And he did this only out of concern for her safety and that of other players on the team. Now, as this trial progresses, I ask that you all keep a keen eye out for the assumptions that the plaintiff would like you to make, and dismiss these assumptions. If you do this, and concentrate only on the incontrovertible facts of the case, I am certain that you will find for the defendant. Thank you.
Plaintiff, wish to call your first witness?
Your Honor, before we do so, with the court's permission, I would like to read to the jury the uncontroverted facts on page 3 of the court's final pretrial order.
All right. Go ahead.
Gentlemen, these following facts have been agreed to by both the plaintiff and the defendant. Plaintiff, a high school junior, tried out for the Alville basketball team. Plaintiff is without sight in one eye. Plaintiff and defendant are both citizens of the United States and residents of Alville, Pennsylvania. Defendant basketball coach was, at all times relevant hereto, an agent of Alville Public Schools and acted under color of law. Defendant excluded plaintiff from further participation on the team. Plaintiff has not participated and is currently not participating in the activities of the team as a direct result of the defendant's action. Plaintiff is the author of a school newspaper article criticizing United States government policy in the Persian Gulf. Thank you, Your Honor.
All right. Now your question.
And Your Honor, the plaintiff calls Pat Barron to the stand.
All right, over here, ma'am. Remain standing. Place your right hand on the Bible.
Put your hand on the Bible. State your full name, please.
Patricia Barron, B-A-R-R-O-N.
Do you swear the testimony about to give the court of jury in the matter not trying shall be the truth, the whole truth, nothing but the truth, so help you
Yes.
All right, counsel.
How old are you, Pat? I'm 17. And where do you attend school? Alville Senior High School. Pat, are you involved in any extracurricular activities at school?
Yes, I write for the school newspaper and I play basketball.
Have you ever played basketball on an organized team?
Yes, several. I played for the YMCA team, a summer league team. I played in middle school and I played very briefly for Alville.
Did you finish the entire seasons on these teams outside of school?
Yes, all of them except the summer league team.
Why didn't you finish the entire season on the summer league team?
Well, Dr. Johnson, who was the coach, found out that I was blind in my left eye and he was afraid of a lawsuit, so he asked me to leave the team.
Pat, how did you lose the sight in one eye?
I was hit in the eye with a ball when I was 13.
Have you ever tried out for a team at the Alville High School?
Yes, I did. I tried out for Coach White's team twice.
When did you first try out?
My sophomore year, which would be last year.
What happened at the sophomore year tryouts?
Well, during this time period, I was very insecure about the safety of my remaining eyesight, so I wore clear protective safety goggles to try out. But the only problem was that they seriously limited my peripheral vision, which means I couldn't see very well to the side. When you can't see, you obviously can't play or pass well, so my playing was disastrous.
Did you make the team?
No.
Did Coach White say anything to you about wearing these goggles?
Yes, as a matter of fact, Coach White made it a point to tease me about looking like James Worthy, who's a professional basketball player who also wears safety goggles.
Pat, what happened this year?
Well, this year I really wanted to make the team, so I worked very hard and I overcame my fear, and I decided to try out without the help of safety goggles.
Did you make the team?
Yes,
When were you informed that you had made the team?
November 1st.
Did you receive a physical examination at this period?
Yes, everyone on the team had to see Dr. Pradadori, the school physician, on November 2nd.
Was anything discovered about your condition?
Well, yes, she found out that I was blind in my left eye. It wasn't something I could hide from her. And Coach White was informed at some point in time because that was the reason he gave for dismissing me from the team.
Objection, Your Honor. Witness is speculating as to her reason for being dismissed from the team.
Sustained.
Pat, where...
Maybe I heard that wrong. Didn't she say that that was the reason he gave for her being dismissed from the team?
I believe the witness answered that was the reason that I was dismissed from the team.
Okay, that's not the way I heard it. That's why I backtracked. So I'm going to reverse my ruling. Objection overruled.
Pat, what was discovered about your condition?
Well, Dr. Pradadori discovered that I was blind in my left eye.
When were you informed that you had been suspended from the team?
November 8th,
Where were you told this?
in Coach White's office.
Could you tell me what happened that day?
Yes, Coach White called me into his office and told me that he wanted to speak to me. And during the process of this meeting, he told me that unless I wore protective safety goggles, I would have to leave the team.
Was this acceptable to you?
No, and I explained to Coach White the reason why I couldn't possibly wear the safety goggles, that I couldn't play with them on, but wouldn't see, and he didn't listen to me.
Pat, did you offer any compromises of your own?
Yes, I told Coach White that this subject of eye safety and protective safety goggles had come up in my household before, and that both my parents fully supported me playing without the use of protective safety goggles. They even offered to release Coach White and the school district from liability should I incur another injury.
What was Coach White's response to this?
Again, he flatly refused.
Did Coach White offer you any further advice?
Yes, as a matter of fact, Coach White told me to stick to a safer activity, such as writing for the school newspaper. And that's when I remembered that when I first walked into Coach White's office, I noticed my President Bush article on the Persian Gulf lying open on his desk chair.
Pat, could you briefly explain to me what this article was about?
Yes, I wrote an editorial in the school newspaper at Alville High School criticizing President Bush and his foreign policy. I didn't agree with taking United States citizens and soldiers over to a foreign country.
Pat, when was this article published?
November 7th.
Is the date of this publication the same date that you were removed from the team?
And no, I was removed from the team the day after my article was published.
Pat, now that you have been removed from this team, are you still playing basketball?
Well, I'm going through the motions of playing at the YMCA team, but it's not really the same.
Why not?
Well, at the YMCA, everybody just kind of gets together to play basketball. It doesn't really count for much. But at Alville, I was in a challenging league. I played with good players, and I had an excellent coach.
Pat, why is playing on the Alville High team so important to you?
Well, to tell you the truth, I need to obtain a basketball scholarship in order to pay for college. If I don't have some financial help, I can't pay for it myself, and therefore I can't go. And if I'm not out on the court playing my very best, under the direction and leadership of a good coach with good teammates, there's no way I'm going to get that scholarship, and then I can't go to college.
Thank you, Pat. No further questions, Your Honor.
Questions, Anna?
Yes, Your Honor. Mr. Barron, are you aware of the fact that in order to make the Alville High School basketball team, you're required to pass a physical examination?
Yes.
Well then, didn't that make your original acceptance only provisional?
Yes.
No, Ms. Barron, Coach White gave you the option of wearing goggles, which would have allowed you to continue playing on the team, correct?
Yes, but if I can't play my very best with goggles, then I don't think I would play well.
But you decided not to wear the goggles.
Yes, that was my decision.
So in effect, you were not dropped from the team, you chose to leave.
Yes.
Mr. Barron, you worked hard to overcome your impairments.
Yes, I did.
Did you even try playing with goggles this year?
Well, I played with goggles all through middle school.
But you didn't try them this season.
Not this season, though.
Well, couldn't we expect that you would be able to overcome the impairment of wearing goggles just as you were over to...
Objection, Your Honor. Excuse me. It calls for speculation.
Your Honor, the witness is perfectly knowledgeable of her own abilities. She's overcome blindness in the past. She should be able to tell whether or not she could overcome wearing goggles.
Your Honor, may I be heard?
Certainly.
That's true, she may have the knowledge, but that still requires a speculation of what could happen this year.
The Honorable sustain the objection.
Ms. Barron, isn't it true that you lost sight in your left eye when you were 13 years old as a result of being hit in the face with a basketball?
Yes.
And isn't it
Objection,
true?
Your Honor. It contains the affidavit that it was a ball, not a basketball.
Your
That's-
Honor,
Go ahead.
I'm sorry, I directed the question to the witness, and I think the witness would have a good knowledge of what it was that blinded her.
Well, the agreed statement of facts that I heard was she was hit in the eye with a ball. Now, okay, I'll sustain the objection, but you can lay a foundation for your question.
Okay, that's okay.
Okay.
That's sufficient. Ms. Barron, isn't it true that your passes during basketball sometimes go astray and even hit other players in the face?
Yes, there's been times when I've made mistakes on the court, but I don't think that's unusual to any basketball player.
And how many times were you hit in the face with a ball to make you blind?
How many times was
Yes,
I
how
hit?
many times did the ball hit you?
Objection, Your Honor, that question is irrelevant.
Your Honor, the question is strictly relevant. I'm trying to show that the plaintiff was blinded by the very action that she has on occasion taken, and therefore poses a threat to other players on the team.
Your Honor, may I be heard?
Yes, sir.
Your Honor, that answer is not contained within the witness's affidavit.
Oh. Okay. I think according to the rules, then I have to sustain the objection.
Ms. Barron, do you realize the risks involved with your playing basketball?
Yes, I do. I've thought about them, and I've discussed them with my parents, and I've totally willing to take them.
What about the risk for other players?
Well, I don't think I'm a danger to other players.
Mr. Barron, as far as your safety is concerned, do you consider your good playing in basketball to be more important than the safety of your remaining eye?
I think that the rewards from playing a good full season at Alville far outweigh the minimal risk of playing basketball without goggles.
Now, Ms. Barron, coincidences and assumptions aside, did Coach White ever actually tell you that he'd read your article?
No,
Did you ever actually see Coach White reading your article?
I never saw him actually read it, but I did see it in his office folded over on the chair.
And did he ever tell you that the article was the reason you were dismissed?
No,
Or
never
that you
saw
had to
him.
wear goggles? He never said this?
He never told me that the reason I was dismissed from the team was because of this article, and if it was, I certainly wouldn't have told him either.
So basically, you're just assuming that your civil rights were being violated on the basis of some circumstances.
Well, they're pretty strong circumstances. First of all, it was open on a desk chair in his personal, private office. Two, Coach White is an Army veteran. It's a subject that would be very interesting for him to read.
But you used to write for the sports section of the paper, right?
I write wherever the occasion allows.
And are you aware that Coach White always reads the sports section of the paper?
I can't say as to what Coach White reads in the paper every time, no.
Well, considering the fact that Coach White always does read the sports section, doesn't that explain why there would be a
Objection,
paper
Your
in his
Honor.
office?
Calls for conclusion.
And facts that aren't evidence that I heard. Objection sustained.
Ms. Barron, did you not swear an affidavit on December 3rd, 1990?
Yes, I did.
And in this affidavit, didn't you say, and I quote, "Basketball is my way of proving to myself that I can do anything someone with two eyes can do"?
Yes.
So, isn't it true that basically the goggles, for whatever reason you had to wear them, simply affected your want to prove yourself, and that's why you're upset about it?
Objection, Your Honor. That's a compound question.
I was having a little trouble with that myself. Objection sustained.
Is it true, Mr. Barron, that the goggles simply impair your ability to prove yourself, and that's why you're upset about them?
Well, they impair my vision, which is impaired already, and therefore they do impair my ability to prove myself. But that's not why I'm out on the court, to prove myself. I'm out there for a basketball scholarship, and if that contains proving myself, then yes, I guess you could say that's why I'm there.
No further questions.
All right, thank you, ma'am. You may step down. All right, plaintiffs have another witness.
Your Honor, the plaintiff calls Adrian Dawes to the stand.
Place your right hand on the Bible, please. State your full name.
Adrian Dove.
Do you swear the testimony about to give the court of jury in matter of trial shall be the truth, the whole truth, nothing but the truth, so help you God?
All right, keep your voice up, please, so everybody can hear you. Counsel?
Please state your name.
Adrian Dove,
Where do you live?
1928 Brothers Arch Parkway.
Are you presently employed?
Yes, I'm an art teacher at Alville High School.
How long have you been an art teacher at Alville High?
5 years.
Ms. Dove, when did you first come in contact with Coach White?
Well, as long as Coach White's been working, I've been in contact with him. But the first time that I got a chance to speak with him was at a faculty meeting in the fall of 1988 regarding the spring prom.
Why did you attend this faculty meeting?
Well, as the art teacher with the greatest appreciation and knowledge of beauty and art, they wanted my ideas and my suggestions.
What ideas did you come up with for the prom?
Well, I wanted to paint the floor with flowers, and I wanted to paint the floor flowers and doves. I wanted to paint on the floor flowers and doves, excuse me. And I wanted to transform the bleachers into a cascading waterfall, trying to show man and nature coming together and forming a bond.
What was the committee's reaction to your ideas?
Well, at first they loved my ideas, but then after Coach White heard my ideas, he ripped them apart and was opposed to them.
What was his response?
He said, and I quote, he didn't want any genteel characteristics of pansies to
rub off on his players.
Did you ever attend any of Coach White's basketball games?
Objection, Your Honor. This line of questioning is irrelevant. We're not here to determine anything about the witness watching basketball games. We're here to determine about Pat Barron leading the team.
Your Honor, this is the first question within the line of questioning. I'm going to establish Coach White's notice.
All right, I'll give you a little leeway. Objection overruled.
Did you ever attend any of Coach White's basketball games?
Yes, last year when my brother was on the team.
Did he have a chance to play a full season?
No, he was cut.
Why was he cut from the team?
It was regarding a rule about hair length. He refused to cut his hair like a Marine, so he was cut.
Objection, Your Honor. Hearsay and speculation. The witness is speculating as to why her brother is cut, and her brother is not here to testify as to why he was cut.
Your Honor, may I be heard?
You certainly may.
That is not hearsay and is not speculation. The witness is just telling what she knows. She hasn't said anything about what she heard.
All right, pending cross-examination, I'll overrule the objection. You can cover that as a issue.
Why was
You
he
may
cut?
have to strike the testimony later.
Why was he cut from the team?
It was regarding a rule about hair length. He refused to cut his hair like a Marine, so he was cut.
May I direct your attention to November 7th, 1990? Can you recall any events that happened that day?
Yes, I was on the way to the gymnasium with a couple of students to paint a sports mural.
Do you recall hearing anything?
Yes, I overheard Coach White ranting and raving about an article that one of his players had written in the school newspaper concerning the U.S. involvement in Persian Gulf.
Objection, Your Honor. Witness's answer is beyond the scope of her affidavit. In the affidavit, it does not state that the coach was talking about one of his players' articles.
Your Honor, that is contained within the witness's affidavit.
That we approach the bench, Your Honor.
All right, well, let's double check. I wasn't sure. Okay. Thanks. All right, objection overruled.
Ms. White, did you hear anything?
Yes, I overheard Coach White ranting and raving about an article that one of his team players had written in the school newspaper concerning the U.S. involvement in the Persian Gulf.
What did he say?
He said he didn't want any long-haired peaceniks on his team because that's what did them in Vietnam.
Your Honor, may I approach the witness?
For what reason?
I want to use this exhibit.
Then you certainly may.
Let the record reflect I am showing the opposing counsel what is marked as Exhibit 2. Let the record reflect I am showing the witness what is marked as Exhibit 2. Your Honor, would you like a copy?
Please.
Ms. Dahl, can you identify that exhibit?
Yes, this is a diagram of the high school.
Does that diagram accurately reflect the floor plan of the high school as you know it?
Yes, it does.
Your Honor, may I offer what is marked as Exhibit number 2 into evidence?
All right, you may.
Your Honor, may I publish what is marked as Exhibit number 2 to the jury?
Any objection?
No objection, Your Honor.
All right, then you may publish it.
Ms. Dahl, can you point out on that exhibit where you were when you heard Coach White speaking?
Yes, I was inside the gymnasium near the inner portion of Coach White's office.
Let the record reflect that the witness has pointed as to being located inside the gymnasium near the inner portion of Coach
Objection, Your
White's
Honor.
office.
This is beyond the scope of the witness's affidavit.
Your Honor, may I be heard?
Yeah.
That is within the witness's affidavit, and if you, I would like to call a sidebar.
Okay. Is it with it? Okay. Yeah, where you at? Thank you.
Ask for the quote that she just gave. She said that as I showed her, she was leaving the gymnasium.
just for clarification reasons, I would just like to state once again, she has pointed as to being located inside the gymnasium near the inner portion of Coach White's office. Ms. Dove, when you heard Coach White speaking, was the door to his office open?
No, it was closed.
Did you recognize the voice?
Yes, it was Coach White.
Are you sure?
I'm positive.
According to that diagram, is there a wall surrounding Coach White's office?
Yes, there is, and that just goes to show how loud Coach White was screaming.
Thank you, Ms. Dove. No further questions, Your Honor.
Cross-examine.
Ms. Dove, you could say that you and Coach White haven't had the best of relations?
No, we don't really cross paths.
Well, weren't you angry with Coach White after he cut your brother from the team?
I wasn't angry. I still respected him as a coach.
Well, weren't you also angry at Coach White after he ripped apart your prom idea?
Coach White was verbally abusive and nasty, but still I wasn't angry. He was entitled to his opinion.
You weren't angry. On November 30th, 1990, you swore an affidavit, correct?
Yes.
In this affidavit, didn't you say, after that incident, I kept my distance from Coach White, a direct quote?
Yes, as I stated before, we don't cross paths. I still respected him as a coach. I wasn't angry by it. We don't cross paths. We don't see each other.
Now, on November 7th, you claimed to have heard Coach White yelling.
Yes.
In your affidavit, didn't you state, and I quote, as I turned to leave the area, I heard Coach White?
Yes, but I knew the door was closed, so I was inside near the inner portion of Coach White's office.
But you had turned to leave the area when you heard Coach White.
Yes, but I heard him. It was done.
Isn't the exit across the gymnasium from Coach White's office?
Yes, I believe so.
And Coach White's office, as you said, is walled in.
Yes, it's Robert.
And the speaker was in the inner office with the door closed.
Yes.
And with all these physical barriers, you were still able to clearly discern every word?
Yes.
Did you see who was in Coach White's office?
No, I didn't.
Couldn't someone else have been in Coach White's office?
Objection, Your Honor. That's your conclusion.
Go ahead.
Your Honor, this does not cause for a conclusion. This is a matter of fact as to whether, since she did not see who was in there.
Well, it's a form of the question, I have to sustain the objection.
Coach White may not have even been in his office, correct?
That could be true, but I recognized Coach White's voice, and I'm sure it was his.
Well, wouldn't a voice be muffled by all of these physical barriers?
Objection, Your Honor. The witness is not a physics expert.
Your Honor, this does not call for any scientific analysis. It is a known fact that
It's probably not.
barriers cause muffling.
Your Honor, I haven't heard.
Yes.
He's asking her, could sound travel through barriers and walls? She is not a physics expert.
Well, objection sustained, yeah.
Now you say that you cannot, how could you clearly hear every word that he said?
He was screaming very loud.
Did you hear the speaker refer specifically to Pat Barron?
No, he said a team player that had written an article in the newspaper concerning the U.S. involvement in the Persian Gulf. And I knew that Pat Barron had written the article, so I just assumed that it was him.
You knew Pat Barron had written the article, but isn't it true in your affidavit you stated that it wasn't until later that you had heard, that you had read the article?
Oh, yes, I'm sorry.
Aren't you just assuming that the speaker was speaking about Pat Barron since you did not actually hear him mention Pat Barron?
I would say I assumed it, but afterwards I knew that it was Pat Barron when I read Pat Barron's article.
One last question, Ms. Phillips. In your affidavit, didn't you say, I quote, Pat was one of my favorite students?
Yes.
No further questions.
All right, you may step down there. Thank you. All right. Plaintiff, have any further witness?
Your Honor, at this point, the defense would like to make a motion to demur to the plaintiff's case. We feel that the plaintiff is not...
Okay, wait a minute. I didn't get an answer to my question.
Your Honor, the plaintiff has no further witness.
All right, just so we have that on record. Now,
We'd like to make a motion to demur.
all right, and the reason?
We feel that the plaintiff has not supplied sufficient evidence to support their claim.
Your Honor, could you
Response?
ask opposing counsel to clarify what he means?
Your Honor, we would
Well, really. All right, I've been informed the rules don't provide for this, so it's a good move, though. In a civil case, it's the appropriate time to do it. I'll discuss that a little more at the end. So I'll have to deny your motion at this point. We'll proceed with the defendant. Okay.
Your Honor, the defense would like to call Coach Bobby White to the stand.
Second.
Raise your right hand and I'll state your full name.
Bobby White.
You do swear the testimony about to give the court and jury in the matter of trial shall be the truth, the whole truth, and nothing but the truth.
All right, take your voice up so everybody can hear, including the jury, sir.
Coach White, could you describe for the court how you're currently employed?
Yes, I am a world cultures teacher and a basketball coach at Alvo Senior High School.
Now, what experience do you have in playing basketball or coaching basketball?
I played quite a bit when I was younger. In fact, I was an all-conference basketball player in high school
And how long have you been the coach at Alva Senior High School?
for 3 years.
Now, what did you do before that?
For the 20 years preceding my employment and coaching at Alvo, I was a career officer in the United States Army.
And could you describe for the court your history with the military?
After leaving college in 1967, I entered the Army. I served for 20 years and left in 1987.
So would you describe yourself as very patriotic?
If you would say, define patriotic as a person who believes strongly in the values and Constitution and American rights.
Objection, Your Honor. Irrelevant. Move to strike.
Your Honor, we are giving the jury character of the witness.
Objection overruled.
Could you please describe to the court how you came to know Pat Barron?
Pat tried out for the Alvo High varsity basketball team in her sophomore year last year. At that point, I didn't feel that her talent was, that she was quite good enough to be playing varsity basketball, so she did not make the team.
Did she try out again this year?
Yes, she did, and I was able to see that she had improved, I guess, through practice. But,
Did you accept her to the team?
yes, I provisionally accepted her to the team, pending the results of her school physical.
Did she undergo this physical?
Yes, she did.
And what were the results of this physical?
I came to know that she was blind in her left eye
And when did you learn this?
on November 3rd.
What did you decide to do about this situation?
Well, after a long thought-out decision, I decided that if Pat were to continue playing, she would have to wear protective goggles.
And why did you decide this?
Well, after consulting the school principal, the school nurse, and sports medicine doctor, and my own knowledge of basketball, I just came to realize that the dangers that Pat posed to not only herself, but other members of the team were too great to warrant her playing
Now, when did you tell Pat Barron the decision?
on November 8th.
You found out on November 3rd about her blindness, and yet you waited till November 8th to tell her. Could you please tell the court why it took you 5 days to approach Pat?
Yes, November 3rd was a Saturday, and I could not contact the principal who I talked to until Monday. But after talking to the principal and the school physician and the sports medicine doctor, I came to the decision that Pat would have to wear the safety goggles. And it's basically common knowledge that the first few days of practice in any sport are strictly drills with very little chance of physical contact or physical injury. And those 3 days could only serve to affirm my decision.
What effect would the goggles have on Pat Barron?
I felt that they could possibly, for a short time, make Pat a less effective player. But I felt that Pat was obviously a person with a lot of perseverance. She overcame an incredible handicap in her blindness. I felt that she could overcome the impairment of the eyes.
Objection, Your Honor. Speculation. Move to strike.
Your Honor, the coach is an experienced basketball coach and basketball player. He is able to tell the effect that goggles would have on one of his players.
Your Honor, may I be heard?
You certainly may.
While that may be true, it still calls for speculation on the part of the witness, and the witness is not an expert in these matters.
The witness is an expert basketball coach, sir.
Yes,
Objection sustained.
How did Pat react to this offer?
She said that she was going to leave if she couldn't accept the offer.
Now, Pat Barron's parents offered you a release of liability. Did you accept this?
No,
And why did you not accept this?
I feel that Pat's parents' offer misses the point. I'm not concerned with litigation or with liability or being sued. I'm concerned with the safety and the well-being of Pat and my other players. If Pat were to be injured, or any of the other players to be injured, I couldn't live with that on my conscience.
Did you hear the testimony of Adrienne Dove tonight?
Yes, I did.
And in her testimony, Adrienne Dove testified that she supposedly heard you in your office on November 7th ranting and raving about peaceniks. Were you in your inner office doing this?
I may have been in my office, but I at no time said those things.
Coach White, are you aware that the plaintiff, Pat Barron, writes for the school newspaper?
Yes, I am.
And have you ever read anything by Pat Barron?
Yes, Pat often writes sports articles for the newspaper, and quite often read the sports section.
Did you read the political work written by Pat Barron concerning the deployment of troops to the Persian Gulf prior to these proceedings?
No, I have not.
Now, did this article play any role in your decision, any role whatsoever in your decision to ask Pat Barron to wear goggles?
It couldn't have. I hadn't read it.
No further questions, Your Honor. I offer the witness to cross-examination.
All right. Cross-examine?
Thank you, Your Honor.
All right.
Coach White, you went to college on an ROTC scholarship, correct?
Yes, I did.
Isn't it true that you just testified that you served in the armed services for 20 years?
Yes, I did.
So you've been associated with the military ever since college, correct?
Yes, I have.
Coach White, isn't it true that Adrian Dove's brother played in the basketball team once?
Yes, he did.
Isn't it true that he was removed from the team for breaking a team rule?
No, I did not.
Coach White, you don't remember the team rule you dismissed Adrian Dove's brother from the team for?
Objection, Your Honor. This line of questioning is beyond the scope of this witness's affidavit.
Anybody want to show me where it is? Or is it? You have it now? Yeah. Yes, counsel, can counsel point it out to me where it is? Okay, objection sustained.
Coach White, if a player's vision is impaired by wearing goggles, she won't get to play that much, will she?
As I said, I felt that Pat's playing time might be decreased for a short time, possibly even a week, maybe less, maybe a little bit more. But if Pat overcame the handicap of blindness, I think that she could certainly overcome it.
Coach
wearing
White.
goggles.
Can you simply answer my question? If a player's vision is impaired by wearing goggles, she won't get to play that much, will she?
As I said, for possibly a short time.
And a player who has less of a chance of playing on the basketball court has less of a chance of being seen by scouts, doesn't she?
I would say that's true.
You don't like to see talented players go unnoticed, do you?
I think it's a shame for talented owners.
Isn't it true that the decision you offered Pat Barron was to either play on the team and wear the goggles or not to play on the team at all?
I said that if Pat was going to continue playing, she would have to wear the goggles for her own safety and safety of the other members.
And if she didn't wear the goggles, she could not play on the team, correct?
That's correct.
Coach White, isn't it true that you claim that because of Pat's blindness, she posed a threat to the other team members?
Yes, she does.
Coach White, do these goggles fix Pat's vision?
I am not a doctor. I can't speculate on how her vision will be fixed.
Well, do these goggles restore the blindness in Pat's left eye?
Objection, Your Honor. Witness is not an expert as to how goggles affect players' eyes.
Your Honor, may I be heard?
Yeah,
I'm clear it's pretty logical that protective goggles do not restore blindness.
that's why I think that would be within common knowledge, so objection overruled.
Coach White, is it true that you were informed about Pat's blindness on November 3rd?
Yes, I will.
Isn't it true that Pat's article was published on November the 7th?
Yes, it is.
Coach White, did you inform Pat of your decision that she could not play on November the 4th?
I'm sorry, could you please repeat? I couldn't follow.
Did you inform Pat Barron of your decision on November the 4th?
No, I did not. I informed her on November 8th.
You informed Pat on November the 8th, 5 whole days after you found out about her disability?
On November 4th, I hadn't come to a decision.
But you still informed her 5 whole days after you found out about her disability, correct?
Yes, I believe I explained that in very examination.
Isn't it true that Pat's article was published on November the 7th?
I believe it was published on November 7th.
Isn't it true that November the 8th, the day you informed Pat, is the day after her article was published?
I believe November 8th is November 7th.
Coach White, you didn't like cutting Pat Barron from the team, did you?
First of all, I did not cut back on the team. Second of all, no, I did not like seeing her leave.
And cutting a player from the team, that's a very painful decision, isn't it?
If I cut Pat Barron from the team, it would have been painful. But Pat Barron's leaving the team is also quite painful.
But you don't like to lose team members, do you?
I would say any coach would have my own experience.
But yet you can't remember why you dismissed Adrian Dove's brother from the team?
Could have been a number of reasons.
But you don't remember why?
I don't think
Objection, Your Honor. The question is beyond the scope of the
Yeah,
consent.
we already determined that, yeah.
Your Honor, I have no further questions.
All right. Can we step down, sir? Thank you. All right, your next witness, please.
We would like to call Jamie Bench to the stand.
Place your right hand on the Bible, state your full name.
Jamie Bench.
Do you swear the testimony about to give the court and jury in my own time shall be the truth, the whole truth, nothing but the truth, so help you God?
Please state your name for the court.
My name is Jamie Bench.
Jamie, what school do you attend?
I attend Alville Senior High School.
And how do you know Pat Barron?
Pat and I tried out for the basketball team together at Alville.
Did you see Pat Barron play basketball?
Yes, I did.
How would you describe her style of play?
Well, Pat definitely has potential, and occasionally she has some flashy plays which are really neat to watch. However, I do feel that Pat is very dangerous.
Objection, Your Honor. Improper opinion. Move to strike.
This is not an improper opinion. It is based upon her whole affidavit, as we will show in our next questions.
Your Honor, may be heard.
You certainly may.
That may be true that it is an affidavit, however, it is still an improper opinion.
Yeah, whether or not it's in the affidavit doesn't make it proper.
Your Honor.
Objection sustained.
No. Because she is a basketball player, she's seen basketball, she should be able to determine.
She is not an expert.
We do.
Yeah, I'll stay with my ruling. Objection sustained.
When did you first learn of Pat's blindness?
When Coach White informed us that Pat had chose to leave the team.
And what was Coach White's demeanor when he told you Pat left?
Well, naturally, he was very upset. It was obvious that he's been agonizing over this decision for days. However, I'm sure that since Pat posed danger to the other players, that it was necessary that Pat leave.
What kind of, did he give any examples of danger?
Well, from playing with Pat, I can tell you that oftentimes Pat would have these uncontrollable air balls and they'd go careening out of bounds. Oftentimes her passes would hit players in the face.
Miss Bench, she would hit her own players in the face?
Yes, I'm sure it wasn't intentional though. At first I just thought Pat was being careless, but I realized that she can't even help it.
Well, how does it feel to play with a player that is so dangerous?
Well, I must admit...
Objection, Your Honor. Improper opinion.
Your Honor, this is showing the effect that Pat Barron's playing has on the rest of the team.
Yeah, the way you phrased the question, objection sustained.
Did Pat's being dangerous affect the team's play in any way?
Well, I can say it did for me. I felt very intimidated, and oftentimes I was afraid to play with
Objection, Your
Pat.
Honor. Once again, improper opinion.
Yeah, I'm going to sustain that. Objection. You can't argue.
Jamie, how does Coach White treat his players?
Well, he's very considerate. He treats us like we're his own children. He's very caring, protective, and I respect Coach a lot.
No further questions, Your Honor. I now offer the witness to the prosecution.
All right, self-examine.
Jamie, you just testified that there were times when there were some accidents on the court concerning Pat's passes. However, isn't it true that in your affidavit, you state that these accidents were the receiver's fault for not paying attention?
At times, it may have been the receiver's fault. However, at times, it may not have been. It may have been Pat's fault.
Your Honor, may I approach the witness?
For what purpose?
I would like to clarify one of Ms. Bench's statements.
With a statement?
Yes.
You certainly may.
Jamie, do you recognize this document?
Of course, it's my affidavit.
Okay. I'd like you to direct you to these 2 lines on the 3rd paragraph of your affidavit. For clarification purposes, I'm going to read these out loud, and I'd like you to tell me whether or not I'm reading them exactly the way they are printed in your affidavit. I quote, "Worse yet were the times Pat threw a ball into another player's face. I thought at those times that it was the receiver's fault for not paying attention." Did I read that correctly?
Yes, you did.
Now, isn't it true that in that statement, you don't place any of the blame on Pat, do you?
As it's stated here, as you read, it says at those times. However, now that we have been enlightened and we realize that Pat is visually impaired, we realize that there's a legitimate reason as to why Pat's errant passes were so wild.
That's just your assumption, isn't it?
No, that's not an assumption. I play basketball, Pat plays basketball, and her blindness is a legitimate reason as to why her passes were errant.
However, you don't state that as a positive reason in your affidavit, do you?
In these 2 lines, no, I do not.
Now, isn't it true that in your affidavit, you state that Pat didn't need to telegraph her passes because she had an uncanny sense of where her teammates would be?
She had an uncanny sense. First of all, no one's denying Pat has potential. I think Pat's a great player. However, I think it's very unfortunate that Pat's blindness is preventing her from being able to play for the high school team.
Pat was dismissed from the team November 8th, correct?
No, Pat chose
Excuse
to
me,
leave.
November 7th.
Pat chose to leave November 8th.
8th. Isn't this the same day that Coach White put you on that team?
Yes, being that Pat chose to leave, Coach needed another player. That's why I came in.
So you filled the void created when Pat left the team.
I took Pat's position. Yes, that's correct.
So what it comes down to is, if Pat is reinstated onto this team, there's no longer any room for you, is there?
That's completely incorrect. I have been practicing a great deal. My basketball ability has developed significantly, and I can honestly say that I'm better than a lot of the other players on the team at present.
Objection, Your Honor. I don't believe that is in the
Your Honor, may I be heard?
Certainly.
Counselor has asked a question which requires testimony beyond the scope of the witness affidavit, and by the mock trial rules, the counselor is bound by what the witness answers.
Okay. Objection overruled.
To re-clarify the question, the opportunity for you to be on the team happened when Pat was dismissed, correct?
Yes, that's correct.
Now, Coach White is also your world cultures teacher, isn't he?
Yes, he is.
This is the same Coach White who coaches the basketball team you're on?
Yes, there's only one Coach White.
Now, isn't it true that Coach White has taken the opportunity in his class time to express his support for President Bush's Persian Gulf policy?
Yes, yes, he's free to express his opinion as being an American.
Now, you agree with this opinion, don't you?
Coincidentally, yes, I do.
Coach White is in this room today, isn't he?
Yes, he is.
And he's listening to you testify?
Yes.
So Coach White is listening to you agree with his opinion.
Coach White is aware of my opinion, as is everyone else.
This is the same Coach White who decides who plays.
Objection, Your Honor. This line of questioning is totally irrelevant.
Your Honor, may I be heard?
You don't have to be. Objection overruled. You may go.
This is to clarify. The Coach White who's sitting here, listening to you agree with his testimony, agree with his opinion, is the same man who decides who plays and who doesn't play for the basketball team that you are currently on.
The coach sitting here at this very moment is not the coach, it is Bobby White, and therefore his opinions do not affect his personality on the court, and therefore I don't see the relation.
Maybe you didn't understand my question. Coach Bobby White, the man who is listening to you testify, is the same man who decides who plays and who doesn't play for the basketball team that you are currently on, correct?
As I stated before, the coach is a teacher, a person, and a coach.
Jamie, please directly answer my question.
I feel this is the only way I can answer it.
Your Honor, do you please direct the witness to answer the question
I think the
directly?
witness was a little evasive too, yeah.
Once again, isn't it true that Coach Bobby White, the man sitting here today, listening to you support his decision and his testimony, is the same man who decides whether or not you play for his basketball team?
Yes, that's Coach White.
No further questions.
All right, you may step down now. Thank you. Any further witnesses for the defense?
No, Your Honor. That's right.
Yeah, okay. I'll play what yours All right, defense wish to close?
Yes, we do, Your Honor.
All right.
Your Honor, gentlemen of the jury, counsel, I'd like to begin by thanking everyone for their time and understanding in this afternoon's case. Gentlemen, the plaintiff has come into this courtroom today making two very serious claims of civil rights violations. However, throughout the course of the trial, the plaintiff has failed to provide substantial factual support for her claim. She feels that her First Amendment right to freedom of expression has been violated. She took the stand to support this claim. However, the testimony she offered was filled not with facts, but with assumptions. She assumed that Coach White had some personal grudge against her. The fact is, gentlemen, that Coach White thought very highly of Pat Barron, wanted Pat on the team, thought Pat could be a team leader. Pat Barron assumed that Coach White read the article. The fact is, gentlemen, Coach White testified he never read the article. And Pat Barron assumed that her article was in some way related to Coach White asking her to wear goggles. But the fact is, Coach White had one reason, and one reason only, for asking her to wear goggles. And that was for Pat Barron's own safety. Adrienne Dove then took the stand. She claims to have heard Coach White. She claimed that she heard Coach White on November 7th ranting and raving about peaceniks. But I ask you, gentlemen, to consider. Adrienne Dove had turned to leave the gymnasium. She was going towards the exit with her back to Coach White's office, and Coach White's door was closed. Coach White's office is surrounded by a standard wall. Obviously, it is impossible for Adrienne Dove to objectively and clearly discern everything that Coach White said through these physical barriers. Her biases have influenced her testimony. Her hatred of Coach White, her favoritism of Pat Barron have influenced what she has told the court today. The plaintiff also feels that her 14th Amendment right to personal autonomy has been violated. She claimed that she was dropped from the Allenville High School basketball team. She claimed she was dismissed. Gentlemen, nothing could be further from the truth. Coach White learned of her blindness. He took days to consider what should be done about this situation. He consulted the principal, the doctor. He came to a decision, and he informed Pat Barron that if she wanted to play on the Allenville High School basketball team, she would have to wear goggles. Pat Barron decided this was unacceptable. Pat Barron exercised her right to personal autonomy that she claims is being violated. Pat Barron chose to leave the team. Ladies and gentlemen, Coach White didn't want Pat to leave the team. Coach White thought highly of Pat. Coach White wanted Pat to be a team leader, but Pat chose to leave. Pat Barron felt that it was unfair that Coach White asked her to wear goggles. She felt that it was an unreasonable request and thus violated her civil rights. But I ask you once again, gentlemen, is it unreasonable for a coach of Coach White's experience, both as a player and as a coach, to ask a player already blind in one eye to wear goggles to protect the other eye? No, gentlemen, there never were any civil rights violations. Pat Barron simply made a decision she now regrets. And she has come into this courtroom today with invented charges of civil rights violations in an attempt to find a way back onto the Alville High School basketball team. In deciding today's case, gentlemen, I ask you to focus on the facts that have been presented during the trial. I ask you to look beyond the assumptions that Pat Barron and Adrienne Dove presented in their testimonies. I ask you to weigh the factual evidence presented. If you do this, I am certain that you will find that the truth in this case lies with the defendant. Thank you.
Close for the plaintiffs.
Your Honor, members of the jury, good afternoon. As introduced by my co-counsel, I'm Michelle Worth. Together, we represent the plaintiff, Pat Barron. I'd like to take this opportunity to thank you for the time, consideration, and open mind you have given to our case. Coach White would like you to believe that Pat was dismissed from his team for safety reasons. He also claims that the publication of Pat's controversial Persian Gulf article did not in any way influence Pat's dismissal from the team. However, as the evidence clearly shows, nothing is further from the truth. Pat's life is basketball, and her future depends on it. So she worked hard, and she tried out for Coach White's team her sophomore year. Pat decided to wear goggles, but she found that they impaired her vision to such a great extent that she was unable to make the team. But because her chance to get a basketball scholarship to college so depends on playing for that team, she worked hard and she tried out again for Coach White's team her junior year. This time, Pat made the team without the goggles. Nevertheless, Coach White insists that Pat wear these goggles, even though he knows they would impair her game. But Pat knows that in order to earn this basketball scholarship, she has to do more than just play. She has to perform her very best. Pat made the mature decision to work for what she wants, to take the risks that are necessary to succeed. Pat's parents, who are her legal guardian, support Pat's desire to take responsibility for her future. In fact, they offered to release both Coach White and the school district from any liability for basketball-related eye injuries. But Coach White single-handedly decided that both Pat and her parents were unfit to decide what risks Pat should take. Only he was. Nothing, but nothing, gives Coach White the right to take this responsibility away from Pat and her parents, where it belongs. To do so would be a clear violation of her 14th Amendment right to autonomy. But there's more. And Coach White claims that Pat was putting herself at risk and that the goggles were for her own safety. But he knew that they would impair her vision. Coach White also claims that Pat was putting her teammates and opponents at risk. But these goggles were not magical goggles. They would not restore the sight to Pat's left eye. They would not reduce any risk, if in fact one had existed. Logic says that wearing vision-impairing goggles would only increase any risk. If safety were the coach's real agenda, he would have let Pat play without the goggles. And without the goggles, Pat is a phenomenal player. Team member Jamie Bench testified that any accidents that happened on court were the receiver's fault for not paying attention. That in fact, Pat was so good, she didn't need to telegraph her passes because she had an uncanny sense of where her teammates would be. Gentlemen, While you review Jamie's testimony, please keep in mind her strong bias. Jamie filled the void created when Pat was dismissed from the team. Therefore, it is logical to assume that if Pat is reinstated onto this team, there's no longer any room for Jamie. It is in Jamie's best interest to ensure that Pat is not reinstated onto this team. But Pat was not dismissed from this team for safety reasons. Coach White dismissed Pat Barron from his team in retribution for publishing an opinion that he disagreed with. Now, Coach White says that he never even read this article. Yet there the newspaper was, in Coach White's office, on Coach White's chair, open to page 6. Pat's very article. Gentlemen, please pay close attention to these dates. Coach White accepted Pat Barron onto his team November 1st. Apparently, she wasn't very dangerous then. Coach White was made aware of Pat's partial blindness November 3rd, yet he chose to wait until November 8th, 5 days after discovering Pat's partial blindness, to dismiss her from his team. Why? The real reason is obvious. Pat's controversial Persian Gulf article was published November 7th, the day before. Those, gentlemen, are the hard facts of the case, and we are confident that these facts alone are strong enough to convince you to find in favor of the plaintiff, Pat Barron. But this case is about more than just those hard facts. It is about the right to take a risk. From the Lewis and Clark expedition to Martin Luther King's March on Birmingham, our greatest achievements as a nation have been made possible because someone, somewhere along the line, has decided to take the necessary risk. How many of us are lucky enough to have a dream, a goal so dear that we are willing to put everything on the line in order to realize it? Pat Barron is one of those lucky few. Don't take that dream away. Her future, her rights are at risk. For these reasons, we ask you to find in favor of the plaintiff.
All right. The jury ready to retire to decide upon the verdict? Yeah. But a witness can give an opinion, which the jury is completely free to disregard, if they want. Like any other testimony.
Could someone who's a basketball player and has experience in playing basketball give an opinion related to the game of basketball? Would that be considered beyond their expertise?
That's tough to answer in a vacuum. It would depend on the particular question. If it dealt to the technicalities of playing the game and they were an experienced basketball player, probably they could. As an experienced basketball player, there would be a quote, almost an expert. But it depends on what you couldn't get in what you were trying to get in. So dangerous, the way it was first asked, but then you got it in the other way about the errant passes. Yes.
During my cross of Jamie, she was, I guess, to her credit, very evasive in a demure manner. And I'm wondering how, in your judgment, how long should she be allowed to be evasive before the attorney asks you to instruct her to answer directly?
Long enough for the jury to get the idea that she's being evasive and trying to duck a question. That's a question of timing on your part as a cross-examiner. Somebody might then on the other side, if you've asked it 3 or 4 times, object that you ask the question, at which point then you say that the witness is evasive. It depends on how long you want to go.
Okay.
Yes, sir.
Your Honor, how would you have ruled in this particular case?
How would I rule in this case? Let me find my notes. This is an extremely close case. I think it's very, very tough from the plaintiff's side. I'll tell you some thinking that maybe I would go. The coach said he hadn't read the article. which is, of course, in his favor, and he offered her to let her play with the goggles. And the question, I suppose, was whether that was unreasonable. Then, did the coach know, and nobody gave me this information, just a question that occurred to me, that she would not wear the goggles? Was that, in effect, a way he could nicely get her off the team because of the article? Did I miss something? Never handed it. Did that come out? I missed it.
I'm not going to say whether or not it came out, but I know that he is aware that when she tried out for his team sophomore year, she didn't make it.
Right, with a goggles.
Yes.
Yeah.
Yes, that did come out.
But we didn't get a question, cause and effects, whether she didn't make it because of the goggles or not.
It came out during the defense examination of Bobby White.
And then you come down to the fact whether you come down to the issue of whether the coach actually took away her rights to play, and something also that was done in this trial that was not done in the other two I had was the exhibit. I never saw the floor plan before, and where they could hear the comments of the case. I think the fact that we had the floor plan, it was possible to hear the coach rave and rant, and the fact that the newspaper was emphasized, that the newspaper was open to that page when she was heaved from the team, I think this time I would go for the plaintiff. Well, the other two times I've gone for the defendant, but I didn't have the exhibit, and the newspaper and where the art teacher, Miss Doug, was standing was not made clear to me. This time it was positioned better, so that I think it's an extremely close case, but I think I would go for the plaintiff. Any other questions? And then we'll get to the scorekeepers. I guess that's what you want to hear from. Mr. Flynn.
Yeah, I learned my lesson last time by I won't announce who won until I say. Well, last time I said it, there was too much yelling and screaming for me to say anything else. I want to thank Judge Subers, who's participated for the 5th or 6th year in the mock trial, for giving his time, and I think he's done a good job and handled most of the trials that we've had in Montgomery County.
I would say most of the trials, but I've handled the last couple of years.
Well,
I'll tell you, I really enjoy it. You kids are good.
And the attorneys also, 3 of them who've come up from Delaware County for giving their time during the competition. And Al DeGennaro, who was the district coordinator for District 2, and I know the district coordinator for Delaware is around somewhere, or might have left. And the attorney coaches and the teacher coaches who are here today for giving their time.
Who other coaches?
Your Honor, Jeffrey Abrams, I'm the attorney advisor for this team, and Susan Frankel is the teacher coach, and she really...
Leo Paul, Your Honor, the attorney advisor, and Larry Ziegler, the teacher advisor.
Right.
And I want to remind the winning team that the next trial, the next round will be this Friday here in Montgomery County before Judge Moore.
Judge Moore.
Right. We don't have a courtroom yet, but as soon as I know what that is, I'll let you know.
What time?
Meet the plaza.
At 1:30. But again, meeting the plaza level. So I think I've said enough. The winning team was Norristown. So I'll see you all Friday afternoon at 1:30.
One comment just I forgot to mention it earlier, in real life I would not stand on court. Okay, congratulations, Summer.